Hello, Steve Mullins here with the Health and Safety Channel, and today's video is entitled Making Your Case. Now, this specifically has to do with perhaps making your case in eviction court as an example, and specifically for that. Basically, we're going to talk about a couple of the applicable codes that relate to not just the health and safety, but mold and excessive moisture in the home in which you live and where you're a tenant. And the landlord has failed to remedy or fix these issues. And of course, in other videos, I talked about how they should be fixed. But here we're going to be talking about how you can successfully defend, an eviction in court if it even goes that far. Now, keep in mind, I am not a lawyer in any way. However, because I am in this profession, I've had to become familiar with the laws and codes to some degree because I've had to go to court and I've had to testify. So that's why I'm bringing this out, especially to help tenants who are being bullied or where the landlord is trying to intimidate you just to put you out. For example, if you have a mold issue that you've told your landlord about, maybe they had it looked at, maybe they didn't. And you ultimately had an inspection done by somebody, such as myself, a certified microbial consultant or certified industrial hygienist. Those are the two credentialed people I recommend having do those inspections because they at the top of the credential list and will give you the best evaluation and recommendations, where other inspectors may or may not. But if you have one of those reports that shows, yes, you have excessive mold or moisture issues that can make the place uninhabitable, and that is a health and safety issue, and then you have that inspector there at eviction court to testify, to my knowledge, you will not lose the case. You will, in fact, win if it even goes before the judge to testify. Because in most all cases, when you have the landlord there trying to put you out, but they may already have the inspection report you gave them some time before, but are essentially ignoring it and still trying to put you out. But if you get to court and have that report and the inspector to back that report up, they will many times want to settle with you out of court before actually going before the judge on the day of that eviction hearing. Because the judge will ask you, go outside and talk about it, see if you can work it out. And then they will do that with you, depending, of course, on what you want and what they want and what you can work out. But as I understand it, they just simply cannot win the case when you have an expert witness, meaning one of the inspectors I mentioned, and a report showing there is an issue that needs to be dealt with that is a potential health and safety issue in your house. But if you don't have that, then all bets are off. Now, the specific law that I'm referring to went into effect in January 2016. And this is it right here. I'm going to put a copy or a screenshot or two of it on there for you. It's Senate Bill 655, Chapter 720. And I say it that way because that's the way it was listed. And I think they reuse a lot of these numbers because of the fact that they do this every year. Now, this has to do with adding to sections 1941.7 to the Civil Code and to amend sections 17920 and 17920.3 of the Health and Safety Code relating to housing standards. Now, of course, this is all in California, in case you're outside the state watching this. Now, and every state has their version of this. You just have to find out what that is. And but aside from that, let's continue on. Now, one thing that the bill updated was the definition of mold. I don't know what it was before that, but this is what it is now. It would define mold as microscopic organisms or fungi that can grow in damp conditions in the interior of a building. Now, fungi, of course, is the other word for mold. Microorganisms have to do with anything that's all living matter at the microscopic level. And we're referring generally to bacteria, but especially bad bacteria that produce pathogens and endotoxins, which are potentially fatal once you have moisture going in a home for about a week. Now, that's explained more in detail on another video. But that's why it becomes such a health and safety issue when you have moisture in the home, even if you don't see any visible mold. Some attorneys I know have talked about this bill and think it refers to visible mold, which is baloney. When it says microorganisms, what does it tell you? Common sense. It's microscopic, right? You got to use a microscope to see it. And it's more about what you can't see than what you can see. Very much like an iceberg. You usually see the tip of the iceberg above the water, but most of it is below the water. So if you see visible mold on a wall, and it's because the wall is wet inside, then you're just seeing a tip or a very sample of the mold that is growing. Most of it is inside the wall or under your flooring, perhaps. Regardless, let's continue on. So it updated that definition of mold, and then on the section 17920 of the Health and Safety Code, which was mentioned, it amends several parts of it. One part talks about nuisance. Now, mold is classified as a nuisance because it endangers your potential life and health. And that's what a nuisance means. And I'll have a screenshot of these things on there so you can see them. Now, it actually talks about that in 17920.3 of the code, which is listed on this page 2 right here. And I have some things highlighted, so some of that applies, some of it doesn't. But where I have that highlighted at 17920.3, at the second half of that, where you see the orange, it says the conditions to an extent that endangers the life, limb, health, property, safety, or welfare of the public or the occupants thereof shall be deemed and hereby is declared to be a substandard building. Now, there's a lot of things that can make something uninhabitable. And in this case, these conditions can make your home or wherever you're living uninhabitable. It doesn't mean you can't live there at all, the word uninhabitable, that is. But it simply means that there's one or more conditions that the building does not comply with in these codes. Now, however, in the case of mold or moisture issues, that can make the entire home uninhabitable. Now, it doesn't mean you may move out the next day, but it does mean that until the issue is fixed, the landlord can't legally charge or collect rent. Now, that doesn't mean they're going to stop trying to charge you, but that's where you need to have an attorney or some kind of legal help to communicate that to your landlord so they understand that you know your rights and you're not going to just give them money when they're not fixing the problem. Now, that's part of Renters' Rights of California, which is a PDF you can look up online. Now, so that's that particular section there. Now, we flip over one page, and it goes down to item number 11 of that section, which is under section A, and then it starts listing 1 through about 20 or so. Item number 11 refers to dampness of habitable rooms. That's this page here. Now, I have that highlighted in yellow, and that's something that should not be in the property. Habitable rooms referring to rooms you live in. A garage, for example, is not considered a habitable room because they're not designed for it. Whether or not you have people living there is another matter. But that's why I say that. A garage is not normally included in the living area of a house or an apartment when they talk about square footage, by the way. Not normally. So this is the essence of the basic codes that I'm referring to that apply in your case. And when you go to court, whether you or your attorney do this, and your attorney hopefully would do this, if they're especially an eviction attorney, but these codes need to be put in writing and given to the judge and say, this is how it applies in my case. Because they're only going to address what you bring up to them in court. That's what the judge says. When I've been there, the times I have with clients, that's what they say. I can only address what you bring to my attention. If you don't bring it to my attention, I'm not going to, address it. Now, that means including not just citing the law verbally, but you need to read verbatim what the law is referring to or the codes, and they need to have a copy of that in front of them when you do that. Because that way it's in writing, you're saying it verbally plus it's in writing, and they see it. That's help making your case. Now, your attorney, assuming you have one, should be able to do that. But if not, you want to make sure that they do. That's, in my opinion, would be something that's going to help your case. Now, as I mentioned earlier, if there's a report and the inspector there that shows there's an issue, it's likely not going to go to the trial, so to speak, in the eviction hearing because the landlord knows they can't win in most cases, unless they have some kind of expert witness to rebuke that, which I don't think they do in most cases. They just don't have it. Because if you have the hard evidence, how are they going to win? So, as far as the essence of this video, that's basically it. However, if you go to small claims court, let's say you want to sue your landlord for maybe damages to your belongings because they didn't do something when they should have, meaning you have this mold and bacteria circulating through your house, and maybe you don't have renter's insurance, or if you do, they might still deny the claim. And I say that because in one inspection I just did recently, the renter's insurance did not cover the cost of cleaning or restoring the belongings or even replacing them because they said the leak was from poor maintenance of the house, even though it's not their house. The insurance denied it. Now, it depends on what your policy says, and that's why when you get renter's insurance, you want to make sure you read the fine print or make sure they have some riders they can put on there that will cover pretty much everything. Um, and by the way, it's the insurance agent's job to make sure that they offer you the coverages you should have, or at least make it available to you. If not, they can be at fault and you can actually tag their errors and omissions insurance for not selling you a right policy. But regardless, let me get off that tangent. So you can use this in small claims court because no lawyers are allowed in small claims court in the state of California. This may be applicable to other states, I don't know. Now, I do have a legal assistance PDF I can send you. I've mentioned that in some other videos. I just can't talk about it in detail because I'm not allowed to. But it's sort of a cheap way or an inexpensive way to help you start in the process. So you don't have to go out and hire a lawyer for $2,000 walking in the door because most attorneys won't even talk to you unless you give them a retainer of maybe $2,000 or so just to even start talking. And then they'll bill you for their time, and maybe you'll get some of that money back and maybe not. Or they may have to charge you more depending on the situation. So those are things to think about. So that legal PDF and what it can do for you, simply send me an email or request it in the email that I put below this, which is info@ocmolddetection.com, and I can send you that PDF and a brief explanation on how that works. So as long as you make your case going to small claims court and citing the law and so forth, then the judge is likely going to grant you what you need. And the landlord can't use a lawyer either. They can only defend themselves if they can with what they have. They can't have a lawyer there doing it. And so if you make your case with these codes and the law and show the evidence that you have, pictures and everything, and write what they call a brief of why you think the law applies and what they are in this situation, similar to what I showed you, then you will likely, hopefully, win your case and get that money to help restore your belongings. Of course, that is under $10,000 in California. In other states, it may be more, and you have to follow their rules, which I have no idea what they are. Anyway, thanks for tuning in. We'll try to give you another video soon on another related topic. Stay safe. Goodbye for now.